Okay, well, welcome everybody. We're going to get going. We're doing a webinar today on the kind of the evolving landscape of cybersecurity, privacy, and AI compliance. And it's kind of a really hot topic area given everything that's happened in the couple of last years. My name is John Rondini. I'm the co-chair of cybersecurity here at Brooks Cushman.
I'm James Bertino. I've been at Brooks Cushman for 12 years. I am currently a shareholder at the firm.
Hi, my name is Ava Fadipe. I've been in practice for about 14 years.
My name is Mohammed Swani. I'm the associate in the data privacy group here at Brooks Cushman.
Okay, with that, we're going to be the presenters today, and we're going to go through a number of different topics. And like I said, in the recent years, the privacy profession has grown rapidly, and that's requires stronger compliance practices, effective responses due to data breaches, and just technological advancements. The role of privacy professionals has expanded significantly over the last couple of years, and it has blossomed into different areas, including AI governance, data ethics, cybersecurity compliance, and just platform liability. Over the last couple of years, about 8% of privacy teams are now taking on duties beyond those traditional privacy roles that we saw when the first privacy laws popped up back in 2018, 2019, the GDPR and CCPA. And that's required an increase in complexity in the roles of privacy professionals in general. So today we're going to look at some of those different topics and how they've changed over the last couple of years, including the significant changes to state privacy laws, the growth of state health and child privacy regulations, and the rapid rise of AI legislation, and the implications each of these has on a different organization. So with that, we're going to jump into our first topic today. That first topic is kind of probably one of the biggest one that's occurred over the last 2 years. It's the change in the U.S. privacy laws. And the change in the U.S. privacy laws is really rapidly changing over the last couple of years due to just the rise in different variations of state laws. And with that, I'm going to turn it over to Ava and let her talk at a high level about some of these changes that we're starting to see.
Sure. So since the enactment of the California Consumer Protection Act back in 2020, we are now at about 18 states that have passed similar laws. Laws that were passed soon after California, they were all very similar to California's law, with very minor changes and definitions or what they consider things like maybe sensitive information. But now what we're seeing is a complete divergence from California's framework. And we're seeing a lot of variations, which we're going to talk about in the next couple of slides. But some of those variations do include things like the applicability of that law to businesses. What are some of the factors that states are now looking at to exemptions, the type of exemptions available and who those exemptions actually apply to. Now, some states currently do have pending legislation like Michigan, Ohio, and Pennsylvania. So we'll be keeping a very close eye on those 3 states. One of the things that we've noted is that the right to private action has become one of those factors that may become an issue for an enacting in law. And we'll talk about that a little bit more. But we saw that this summer with respect to Vermont. When the bill came to the governor's desk, he vetoed it. Unfortunately, they weren't able to override the veto. And one of the issues was, I believe, the private right of action.
Okay, and with the gray bills or the gray states that are up here, that doesn't mean that there's no bill at all. It just means looking at them, right?
Correct. That yes. So it could mean that they had something but just wasn't able to go through. But yes, doesn't mean that there's nothing
Active right now.
Active right now.
Okay, and with that, so as Ava just mentioned, we've seen an increase over the last couple of years in various states, and that's what the previous slide just showed, is all these new states that have laws that either gone into effect in 23, states that have laws going into effect in 24, and some in 25 and 26. So we've just seen an increase in state privacy laws. And it used to be back in about 2019, 2020, when the CCPA came out, it was a pretty easy for companies and entities to kind of look at it and say, okay, all I got to look at is I can look at the jurisdiction threshold, and I can look at what the CCPA says in terms of how I meet that law. And what this slide is meant to represent is the criteria typically defined for, different jurisdictions. It varies vastly. Most of the states have a similar jurisdiction aspect, which is on the left-hand side of the screen, which is either the company or entity conducts business in the state, or they produce products or services that are targeted residents of the state. So a lot of the laws are very similar in scope of jurisdiction. Where it really diverges is in the various thresholds. After you hit the jurisdiction, then you got to hit one of the various thresholds. And as you can see, there's different thresholds. There's a threshold regarding the volume of personal data processing during a calendar year. And that can vary from as little as no volume whatsoever. You handle one resident and then you hit the threshold for Nevada and Texas, all the way up to 175,000 consumers in Tennessee. And the variance is, as you can see on the screen, vastly different between the other states. So you can't just look at California, which I highlighted in red there, of 100,000 consumers anymore. You're going all the way down to one, all the way up to 175,000 now. And that's the first threshold. The second threshold is kind of an and. You have to hit both of these purple prongs. So you've got to control or process personal data of consumers, and you have to have a certain percentage of gross revenue derived from the selling of the personal data. And as you can see again here, Nevada and Texas, they basically have no threshold. So you do any business, you automatically, as soon as you meet jurisdiction, you hit the law. But the other states, the consumer number and the percentage of gross revenue varies from no threshold all the way up to 25,000 consumers and 50% of revenue. So again, we're seeing a huge variance in the various laws between the different jurisdictions or different states. And that's going to cause a lot of changes to how companies have traditionally looked at their policies and how they've handled things over the last couple of years, because now you got to start considering all these various states. And I have down here the last threshold. This only applies to California. California is the only one that really has this right now. Is generates at least 25 million in annual revenue in the preceding calendar year. So for California, it could be threshold 1, threshold 2, or threshold 3. For the other states, it's either threshold 1 or threshold 2. So that's how you're going to fall into the scope of one of these laws. With that, I'm going to turn it over to the exemption and let Mohammed talk a little about some of the exemptions we're seeing in these laws.
So one of the other contentious aspects of these state privacy laws is the growing divergence in exemptions. So from a business perspective, these exemptions and their fragmented landscape can have serious implications. For example, some states exempt small businesses, nonprofits, or even specific entities such as higher education or government. While these carve-outs might reduce the compliance burden for certain entities, they create operational challenges for businesses trying to navigate and operate across state lines. So companies have to navigate this web of exemptions to determine which law applies, and this often leads to over-compliance as a precaution. There's also an aspect of competitive imbalance here, where companies that have to comply with strict regulations are at a disadvantage compared to those that are exempt. Ideally, moving forward, we'll see more of a balanced approach that would harmonize these exemptions across state lines or create federal carve-outs for only the most necessary cases.
Okay, and with that, I know these are specific to the states, but I'm going to let James here talk a little bit about what we're seeing at, with regards to the federal laws and the exemptions and how they apply.
So in contrast to the last slide that emphasized the entry level exemptions, this slide we're talking about specific data level exemptions in the state laws, but specifically regarding some federal laws, such as the Gramm-Leach-Bliley Act that mandates that financial institutions protect the privacy of consumer financial information, the Health Insurance Portability and Accountability Act that sets standards for protection of sensitive patient health information, the Federal Education Rights and Privacy Act that protects the privacy of student education records, and the Fair Credit Reporting Act that promotes accuracy, fairness, and privacy in consumer credit reporting, and the Driver's Privacy Protection Act that protects privacy of personal information and motor vehicle records. So as you can see, California has introduced a data level exemption for all of these different federal acts, and 14 states have followed suit with data level exemptions for these same federal laws. As you can see, New Jersey has no exemption for FERPA. But the emphasis here is that when there's a federal law that covers specific data, that the state laws are going to go ahead and exempt organizations when already covered by these federal laws. A good example of a data level exemption would be hospital records that are protected by HIPAA would be exempt from the state privacy laws, but the hospital itself will still need to comply with state law regarding their employee records. A good example of an entity level exemption would be a credit union that is regulated under the Gramm-Leach-Bliley Act. They would be fully exempt from the state privacy law.
So we talked about, the various laws that have gone into effect, how you fall into the laws and some of the exemptions. So now I want to toggle and talk about some of the business obligations and what we're seeing in terms of these various state laws, in terms of the business obligations they're requiring. So James, if you could just touch on some of those.
Yeah, so part of your business obligations when you're collecting data is you're going to have to provide a privacy notice to the data holder whose information you're collecting. Some of the things you're going to have to do is you're going to have to let them know what type of information you're collecting. Who you're disclosing that information to, specifically which third parties. You're going to have to inform them on how they can exercise any rights they may have towards that data. And you're going to have to provide them with information on how they can get in contact with somebody if they want to exercise their rights. But one of the main emphasis on the privacy notices is that you're going to have, most states require that you describe all the third parties that you're going to be sharing the information with in sufficient detail so that the consumer can understand the nature of the third parties and how they're going to exactly use and process the data. Yeah. So the next question is when are you required to make a disclosure? So some states require that upon request of the consumer, the data holder, that you disclose who the specific third parties are and which the business has disclosed to a particular consumer's personal data or specific third parties to which it has disclosed any personal data. So depending on the state threshold, it could be, large or small. So it could depend on whether a specific request is required or has been made or whether or not any personal data is being collected. California is a little bit different. They require notice at the point of data collection. So when you're collecting data, right away, you're going to have to provide this information to the consumer. Now, Rhode Island has some very specific exemptions and nuances. So Rhode Island requires that any commercial website or internet service provider conducting business in Rhode Island or with customers in Rhode Island or otherwise subject to Rhode Island jurisdiction designate a controller, so the person that's going to control and process the data. If the internet website service provider collects, stores, and sells consumers' personally identifiable information, the controller must conspicuously on its website provide a privacy notice with specific information. The purpose of these requirements in Rhode Island is to provide transparency, accountability, and ultimately to protect the consumer, which is kind of going to be an overarching theme here. And your privacy notices may need to be tailored to specific situations. So for example, if you've got a website or an app or even a storefront, you might need to draft 3 different privacy notices tailored to each of those specific situations.
Thanks. And the bullets that are up here, these are the bullets that generally are found in each of the state regulations and laws. Is that correct? So this is kind of a comprehensive list of all the various states. So some states might require more, some states might require less than what's shown here. And the biggest thing I think you brought up is, in the past, people thought, hey, I'm just going to put one privacy notice up on my website. That's going to be the privacy notice I'm going to move forward with, and that's going to be good enough. Or I'll have one generic policy or notice I'm going to use throughout all my different disclosures. And that's not going to cut it anymore. Like you just mentioned,
That's correct.
You do various aspects. If you have a website and an app, you might need 2 different policies. If you have people walking into a storefront, or you have customers or clients coming in versus going to your website, you might have to have different, notices for those different applications. With that, I want to flip gears and talk about some of the consumer rights in which Mohammed kind of talk about that.
So what are some of these consumer rights? So consumer rights under all current state privacy laws include access, deletion, correction. However, the practical application of these rights may vary widely. So these inconsistencies make it difficult for both consumers and businesses to navigate. So another challenge may lie in enforcement mechanisms. So most states rely on the attorney general of the state to investigate these violations. However, California under the CCPA offers a private right of action for these data breaches. While these provisions aim to empower consumers, they may inadvertently open the door to class actions and benefit plaintiffs' attorneys. So most current states also include opt-out rights for targeted ads, selling data, and profiling as well. However, and also many laws carve out specific rights for minors, reflecting the growing concern over protecting these vulnerable populations amongst us. However, these provisions almost often lack specifics. For example, what constitutes a violation of child's rights, and what is the interplay with current federal regulation that already exists?
Okay, and so Ava, if you could, I mean, I'd like to flip from that and talk a little bit more about the various states again, and if you could touch on, what you're seeing with regards to those various states and the laws.
Sure. So what we've noticed is with respect to companies, the collection of personal data is the key here. And what is personal data? Personal data, as most of us know, is any type of information that's linked or reasonably linkable to an identified individual. And this includes anything from like purchase history to biometrics to user ID. And within personal data is actually a subset of sensitive information. And sensitive information, you're looking at things again like social security number, credit history, GPS location. And one thing to note is that states may have different definitions of what they consider personal information and what they consider sensitive information. For example, biometrics is a new technology, and some states have biometrics explicitly listed as personal information. Others haven't had it listed just yet. It may change though. So right off the bat, businesses have to start looking at, the type of data that they're collecting and make sure that the data that they're collecting fall under the correct definitions. With respect to sensitive information, we want to note that generally businesses have to give consumers notification. So it's kind of an opt-in provision. So you have to get the consent of the consumer to use their information. One exception that we want to highlight is Maryland. Maryland has a very strict rule regarding sensitive information. You are not allowed to sell any sensitive personal information in Maryland. And if you use it, it's only necessary for the specific product or service that the consumer is requested. Now, as we all know with data, we're collecting it and we're collecting, businesses collected like an incredible amount of information. Well, these laws are now kind of limit the amount of information that's going to be collected. And what we're looking at is more of, the use, retention, sharing, and of that personal information has to be adequate, has to be relevant and reasonably necessary to actually perform or achieve the task that the data was originally collected for. So if you are going outside the scope of that original task, the businesses actually have to go out and they have to get consent again. But kind of highlighting on Mohammed's point, what these terms really mean, what is considered adequate, what's considered relevant, and what is the umbrella of protection provided for that use. We're going to probably see that play out in the coming years once some of these cases get litigated. The last thing I'm going to touch upon is the universal opt-out provisions. Many states are requiring them. And again, this is another one that it's just going to vary from state to state on whether or not their notices have to have a universal opt-out.
And so with that, let's just talk real quickly about some of the enforcement and recent decisions we're seeing in some of the, not only state privacy laws that have been in effect, but even some of the laws that are already on the books that states that are enacting privacy laws now. They kind of dusted off the books and used some old laws to capture some privacy violations. So James, if you could.
Yeah, so as we see, the state attorney generals are responsible for enforcement. Again, the caveat is that California does have a private right of action. As you can see, these major decisions over the last few years, we've had 1.4 billion settlement, Texas against Meta for unauthorized biometric data capture. California, a large settlement for collecting children's data without parental consent. Again, in California, another settlement for selling consumer data without notice or without the opt-out options. The one thing to mention here is that in the Texas versus Meta case, the state data privacy law was actually not applied. It was a capture or use of biometric identifier act and the Deceptive Trade Practices Act. So although it wasn't specifically their data privacy law, what we see here is that, states are willing to go after companies for inappropriately disclosing, not properly processing, or not protecting personal data, such as personally identifiable information. And, this can require you to provide certain levels of cybersecurity to make sure you're protecting that data once it's collected. So you do have a duty to make sure that you're sufficiently protecting that data once you've collected it.
I think the important note is with Texas's law going into effect, starting at the end of this year, given that they've gone after Meta already and hit them for 1.4 billion, it's just worth noting that Texas will be probably in the upcoming years, one of the states that's really going to be enforcing their privacy law, as shown by this case. With that, I want to flip to a different aspect. Similar to Texas, what we're seeing where old laws are being dusted off. I'm going to hand it over to Mohammed to talk about SEPA.
Yeah, exactly. We've seen this trend where states are applying old laws to new theories, and the California Invasion of Privacy Act, SEPA, is one of those examples. So SEPA originally was wiretapping or eavesdropping between conversations over a telephonic device. And this has been adopted to the modern context of websites and digital tools. So this started in 2022 with a couple of retailers facing lawsuits for the use of chat windows on their websites. So plaintiffs brought theories under the private right of action in California that these were considered wiretaps. These cases got dismissed. However, these theories continue to evolve. So we saw an unfortunate decision in Greenlee v. Cocava, where the court refused to dismiss a lawsuit involving software that collects and correlates consumer data. And these tracking cookies are fairly common across websites. However, this interpretation penalizes companies for using data in a widely accepted way that all companies do to enhance the consumer experience. So from that, we've seen cases like Flash v. Cable News, where CNN faced similar action for using tracking software on their website. And doing a search of these cases last year, there have been hundreds of cases filed in 2024 under SEPA theories in California state court. And majority of these cases involve common tracking technology like Google Analytics, TikTok pixels, and Meta pixels. So what are the real impacts of these interpretations? So businesses now have to spend more money litigating these theories and less money on their core competencies. And these laws, they were originally intended to protect against clear invasions of privacy. They're now sort of being weaponized to stifle activities and the usage of data. And it's sort of hard to say, are these kind of protecting against genuine invasions of privacy, or are they preventing businesses from their routine data practices?
Okay. And so we've talked about some of the variations, the enforcement, we've talked about SEPA, and then some of the whole laws are being dusted up. What we're seeing also is we're seeing Colorado is one of the first states that's starting to do these add-on bills, as I'd like to call them. Basically, they've had a privacy law in effect, but over the past year, what we've seen them do is they've started to throw bills and that have gone into effect on expanding that privacy law. And the two bills of note are the Privacy of Individuals' Biometric Identifiers and Data and the Children's Privacy Act. And what they've done there is they've basically expanded the scope of what the controllers need to do. You have for the biometric one, it requires a person that controls and processes one or more biometric identifiers, basically protect the individual's biometric data. And then you have the same thing with respect to minors' data. And what's really interesting about these two bills is the first one will both go into effect in 2025. You're seeing that for children's privacy acts, they're not going to allow it to be retroactive. So it's going to go into effect in 2025 with no retroactive allowances there. So that is something interesting we're starting to see. And as we'll talk about a little bit later, Colorado is also one of the first states that threw out an AI bill. And so they're very active. They're kind of leapfrogging California right now in terms of just jumping ahead and adding on these new terms onto the privacy bills of what needs to be protected. So with that, that's kind of in a nutshell, what we're seeing at the state level here in the U.S. And what I want to do is I want to turn it over to Ava and let her talk about what we're seeing at the international level.
So as much variation that we're seeing in the US, we're seeing a lot more, obviously, internationally. So in the US, like we mentioned before, many people relied on California's law as a kind of like a guide. Well, internationally, people have been looking towards the EU's GDPR that came out, I believe, back in 2018. And there are similarities, obviously, between what's happening in the US and internationally. Obviously, we have things like establishing right for data for consumers, that's there. And then the obligation on businesses to protect that data and the handling of that personal information. There are, a couple of distinctions that are very much worth mentioning. One is the fines. Europe is known to have very severe fines if you are in non-compliance with the GDPR, as you've probably seen in the headlines and we'll mention shortly as well. And also the idea of like cross-border data transfer, which came up with the GDPR and has many international countries like India, China are also using as well. So this year in particular, I'm just going to touch on a couple of changes worth noting. Australia recently amended their 1988 Privacy Act, and in there they gave the private right of action so that consumers can go and file suit against businesses. They also added the Children's Online Privacy Code to their Privacy Act as well. Chile actually also approved their data privacy law in November, and it aligns pretty much with the GDPR. They also have very stringent sanction systems, and they have serious fines that can add up to $1.5 million. Vietnam approved a new law that was really directed towards this cross-border data transfer concept. In there, they said that they would be willing to accept data from abroad, personal information, and they would, provide rights to owners of that data and at the same level as their own citizens. So with that, as if your data is being stored in Vietnam and you find non-compliance, you could possibly potentially go after the company in Vietnam if Vietnam allows that. It's worth noting, however, that Vietnam has very strict rules regarding its own data of its citizens. And if it's personal information that's not sensitive, it could be transferred. However, there's very strict guidelines. And if it's sensitive information, they will not allow it to be transferred to other countries. So China, of course, we can't not say anything about what's happening over there, but one of their provisions of self-supervision audits is coming into effect in 2025. And they released some standards back in the summer for companies to kind of look at and guide and determine how to do these self audits. So it'll be interesting to see next year what comes out of that and how companies are actually starting to do those audits and what are the ramifications if they're not done correctly.
Okay. Well, thank you, Ava. And with that, we're going to toggle away from state and international privacy, and we're going to jump into another emerging trend we're seeing out of the states over the past year, which has been consumer health laws, in particular, this significant push to enhance consumer health data privacy, especially for data sources from wearable devices to fertility tracking apps and just beyond that. And two states have kind of taken this bull by the horns, and I'm going to hand it over to Mohammed to kind of talk about those two states and the laws that we're seeing pop up.
Yeah, so health data privacy has definitely emerged as a critical issue driven by the proliferation of telemedicine and these digital health platforms. So Washington introduced the My Health, My Data Act, MHMDA. Nevada has SB 370. So these recent laws highlight this trend, but their implication may raise some concerns. So these laws impose strict requirements for collecting, storing, and sharing health data. For example, Washington's MHMDA mandates explicit consumer consent before collecting health-related information, while Nevada's law emphasizes consumer opt-out rights. So these laws are well-intentioned. However, they may introduce compliance challenges. Businesses have to segregate health data from the other types of consumer data they may collect, and this may be an operationally complex and challenging task. So these state laws may also have broader implications with the national frameworks that currently exist, like HIPAA. So while this focus on health data is important, a piecemeal approach to regulation may create more problems than it solves.
And I think we see that in particular, I want to flip to the next slide here with respect to this, MHMDA law. And I put up on the screen here, we have a division between the federal law HIPAA and the MHMDA. And I just highlighted and read a couple of nuances. And just like Mohammed just said, I mean, it's going to create a huge complexity because not only do you have HIPAA, which, focuses on certain covered entities, now we have these state laws which expand beyond those covered entities, and almost any organization that collects this type of information may be subject to these state laws. And one of the really big aspects, especially with respect to the MHMDA Washington law, is that you can see it's got a private right of action to it. The Nevada one does not have a private right of action, similar to HIPAA. So that's going to be something that we're going to really have to watch because, as we saw with the CCPA, private right of actions bring a lot of litigation. So I think this one is one that we're going to have to keep our eye on. And on top of that, as Ava talked about earlier, we've seen variations to different laws like the CCPA, where they expanded the sensitive personal information, and they now have expanded to the point now that it protects data related to contraception, pregnancy, and abortion. Classifying that as sensitive personal information that requires additional privacy safeguards. So beyond just these two state laws, we're seeing some states kind of modify their privacy laws and including health, information as sensitive personal information under the privacy law. And with that, we're going to toggle into probably one of the hottest topics in the past 2 years, or the most talked about, I don't know about hottest, and that's AI, artificial intelligence. And AI is not something that's new. AI has been around for decades. But what is newer is the generative AI. Chat GPT, Gemini. Those are two types of generative AI that are very prolific and everybody's starting to use. And we've seen them really rise over the last couple of years. It's a rapidly advancing technology, but it requires that in order to train these generative AI system, it requires a vast amount of data sets. And that data set that's being consumed is not only public information, but it's starting to consume a lot of private information. We're seeing these systems scrape websites and pull information down and use that to train these generative AI systems. So what is becoming a concern is the algorithmic bias, the misinformation, possible privacy violations that now require some type of AI governance. So we're going to provide a little overview and look at some of the current legislation going into effect this year and forward in 2025 and beyond. So AI compliance, what is it? It's basically, how a system is going to be, designed, how it may be deployed, how a corporation may ingest and use an AI system. And all of these things are important because even if you're not developing your own AI system, if you're using something like ChatGPT, well, there's various versions of ChatGPT that you could use, or that your company could use, or engineers or employees within your company could use. And unknowingly, they could be inputting or allowing that generative AI system to consume private information, not only private, confidential information, or information about people that will now be subjected to privacy laws. So AI compliance has kind of been falling under the umbrella of privacy professionals in the last couple of years. And there's a lot of reasons why that's happening. One of the biggest ones is the roles and responsibilities of privacy professionals kind of line up and mirror what we're seeing with the AI, not only in terms of how it's handled, but in terms of the data and everything that's going on with it. So that's why we thought this was a very pertinent topic. So one of the topics that we can't get away from is talked about GDPR a couple of years ago. And so now we're going to flip over and talk about in Europe, the biggest act that's gone into effect is the EU AI Act. Let Mohammed touch on that.
Yeah, so the EU AI Act is the first comprehensive regulation of AI, but its implications are concerning for businesses worldwide. So this law divides AI systems into 4 risk categories. There's prohibited, high risk, limited risk, and minimal risk. And there's severe penalties for non-compliance, including up to 35 million euro or 7% of the organization's total worldwide turnover. So high-risk systems are those that are used in critical infrastructure, education, healthcare, and these systems face especially stringent requirements. So these requirements include mandatory risk assessments, transparency obligations, and human oversight. While these measures aim to mitigate the harm, they impose substantial costs on businesses, potentially discouraging the adoption of innovative AI technologies. This act creates comprehensive competitive disadvantages for non-EU companies that operate globally, but may have to comply with these regulations, even if their domestic laws are less restrictive. And the broad scope of this act also raises questions about enforcement and interpretation. For example, how will regulators differentiate between limited risk and high risk when the boundaries are pretty inherently subjective? So this uncertainty leaves businesses vulnerable to regulatory overreach and inconsistent enforcement.
And I think one of the biggest things that companies really need to be aware of is the point you touched on, Mohammed, that you don't have to, much like the GDPR, you don't have to be a company operating within EU. If you develop, sell, or use an AI system that reaches a European customer or a European customer ends up using or consuming, you're going to be subjected to the EU AI Act. Is that correct?
Yeah, exactly.
And so, these penalties, we've been watching the GDPR over the last couple of years, and we've been watching, immense fines coming out of the GDPR for violations. So the penalties here are pretty staggering and significant. So it's really something that companies, if you don't have, AI governance at the top of the mindset right now, if you're not deploying some type of, AI compliance framework, this should really put you into action because it goes into effect. The law went effective this past July, but the first set of provisions, it's going to be phased in over the next couple of years. And the first set goes into effect in 2025 and then 26 and thereafter. So we'll start to see enforcement actions in the next couple of years based on this law. So with that, I want to talk a little bit about what's happening at the state. So I'm going to hand it over to James and let him talk about what we're seeing stateside with regards to AI.
All right, so what we're seeing in the states is, as of right now, we have 3 states that have enacted laws, and we have other states that are introducing bills. So we're going to start seeing more and more AI laws as time goes on. And, similar to the data privacy laws in the states, the overarching theme is transparency and consumer protection. And the specifics of the states who have current laws on the books, including Utah, Colorado, California. Let's start with Utah. So Utah is going to focus on transparency with regard to generative AI systems. In fact, they're going to break it up into a few different categories. So, for example, they're going to break it up between regulated occupations and general business interactions. So, regarding regulated occupations, this is individuals or professionals that require a state license or certification. For example, a healthcare professional such as a doctor or a nurse, they must prominently disclose the use of a generative AI system at the start of an interaction. So your obligation is right away. You need to let the consumer know you're not interacting with a person, or you're interacting with an AI system, or at least being assisted by an AI system. So with a general business interaction, it's not as stringent. So for businesses that are not in regulated occupations, but are subject to Utah's consumer protection laws, requires that if a consumer inquires or prompts about the nature of their interaction, then the business must clearly conspicuously disclose that the consumer is interacting with a generative AI system and not a human. So we can see the difference there between a regulated occupation and a general business interaction. One other thing you need to keep in mind is that under the Utah law, companies cannot evade liability for consumer protection violations by attributing them to generative AI systems. So if you're using a generative AI system, you're going to be accountable for anything that's misleading or harmful that's output by the AI tool. So you're going to be liable for what the AI tool does. So you're going to want to make sure you've got sufficient controls on the AI tool to make sure that it's being accurate. Colorado is going to emphasize their law on high risk systems that we talked about in the last slide. So what exactly is a high risk artificial intelligence system under the Colorado law? Well, Colorado law defines it as an AI system that when deployed makes a substantial factor in making a consequential decision. So they've defined a consequential decision as any decision that has a material, legal, or similarly significant effect on the provision or denial to a consumer or the cost of terms of specific categories such as education enrollment, employment, financial or lending services, government services, healthcare services, housing, insurance, legal services. So if you've got an AI system that's making a decision regarding those categories, it's going to be considered a high risk system. California, on the other hand, is they require disclosure of intellectual property or personal information as defined by the CCPA if it's being used by a generative AI system. And the companies must maintain a detailed documentation and public summaries of the training data that they are using. So all of these states have penalties if you're in violation. If you look, Utah and Colorado have specific penalties, and California, on the other hand, does not have a specific penalty amount. So, they could be significant in California. One other thing to note is that California also does have a private right of action when a plaintiff has been injured and has lost money or property due to an interaction with generative AI. So, again, similar to the data privacy laws, California provides a private right of action while the other states do not.
The other interesting note is California, since it wraps in the CCPA, what you could see in the future is generative AI system, that violates the California AI Act can also be violated in CCPA. So you could be hit with double penalties here, depending on, which law applies, and possibly both laws might apply in certain situations. So it's just something to know. Go ahead, Anna.
Sure. And one thing to mention too is, there are states that don't have any type of laws like this, but they're still going after generative AI, such as Texas and Florida, that recently private citizens and consumers filed suits against chat box, I believe it was. And so businesses still need to be very much aware that they're still on the hook.
Yeah. So even if there's not a law in place, compliance is still should be at the forefront of your minds.
Right.
And with that, Ava, it's a great time for, the next slide, which I'd like you to talk about a little bit. What we saw with privacy, in 2018, 2019, we saw frameworks start to be developed, and what are we seeing in terms of AI?
Same thing is happening here as well. Kind of going back to, the idea of the transparency, the tracking and the flagging of risk with generative AI. The National Institute of Standard and Technology provides an AI management framework that was released in July of this year. And in that framework, they have set out 12 risks that they believe are associated with the development and use of generative AI. Now, each of these risks, provides a lens through which the organization can frame and execute risk management. And the framework itself, has these 4 factors: govern, map, measure, and manage. And the real crux of this framework is the governing portion, because we're going back again to transparency, the policies, the process, the procedures. How are you able to determine whether the AI is actually working the way it was intended to work? And all of that goes back to governorship. And so each of these factors, the other 3 factors, really are intertwined with with governing as well. Now, I can go and sit here and kind of go through all of these, but it's gonna take a lot of time. But I do believe that it's important for organizations to start looking, if you haven't yet, to look at the management framework. Because as John kind of mentioned, like becomes the standard in a sense. You're not required to, in air quotes, but it is the way to go.
And we saw that a lot with the privacy. I mean, we saw violations where companies didn't follow standard like NIST, and that was, set up by either FTC action or by, state laws to be in non-compliance for those privacy laws. So to your point, I believe this framework is something, if you haven't looked at it, like Abba said, is definitely something either you should be looking at or, reach out. We'd be happy to talk to you about this type of framework. And so with that, let's toggle over. I mean, we've talked about, we got the state laws. We know what's going to kind of happen there. At the FTC level, FTC obviously, regulates data privacy strongly. James, can you touch on, what the FTC and their approach that they're taking toward AI systems right now?
Yeah, so the FTC is, taking a regulatory approach similar to their current obligations, securities, and, so one of the things they do is they want to make sure that there's no monopolies across the AI stack. They want to force antitrust laws for key infrastructure such as cloud computing, chip manufacturing, and data storage. To promote fair competition, prevent market concentration. They also are operating to protect the consumer in sensitive applications. You want to make sure the AI systems are avoiding bias, discrimination, privacy violations. The AI application should focus on significant societal impact. They also have a proactive enforcement and market oversight, monitor partnerships, data usage, business models, and ad tech, generative AI, and data brokerage, and to prevent deceptive practices and safeguard consumer interests. So, the FTC is, can focus on transparency. They're going to target deceptive practices. You want to make sure that the consumer is able to make an informed decision, similar to the securities practices. You want to be able to make an informed decision when it comes to buying stocks and bonds, and they want to make sure that the generative AI systems are following suit.
Yeah. And with that, we're gonna step away from AI and we're gonna turn the page to children's privacy law. So kind of like what we saw rise in a lot of changes in the privacy. We saw some rise in health. There's been a vast change in the children's privacy laws. And so with that, I'm going to turn it back to Avo, who's going to step us through a little bit of what's happening at the state level.
Sure. So children privacy laws have been around for a while. There's the federal 1998 Children's Online Privacy Protection Act. So this has established multiple guidelines that many states are following or adapting. But recently, what we've been seeing are laws that are specifically directed towards online platforms. And these laws are intended to enhance privacy and establish safeguards around children. So the next couple slides, we're going to kind of go into more detail, some of the things that we're seeing in these laws and the requirements. But it's worth noting that these laws set out restrictions and safeguards on multiple fronts. They're just not taking, one view. They're attacking this issue from anywhere from, having default settings in the favor of the child to guidelines on what type of information you can display to the child, and the actual design of the website itself. And in some cases, states even have guidelines and restrictions on when online platforms can actually communicate with children. So you're not allowed to communicate them during a certain time of the day. And also the requirement that the child is not allowed to be on the device for a certain period of time. So it's going to be very interesting to see what happens when these laws are enacted and the challenges they may face in the courts, especially with respect to constitutionality. It is also worth mentioning is that when we talk about private right of action throughout this presentation, time and time again, it's been coming up with respect to sensitive information and children's privacy laws. So many states have enacted or are allowing private right of actions with respects to violation or non-compliance to children's data.
Okay. So Mohammed, can you touch on some of the key features we're seeing with some of the state legislation laws?
Yeah, so children's privacy laws have definitely become a focus at the state level, and several states are enacting or expanding legislation beyond what COPPA has enacted. So these states go beyond the general data privacy laws to address the unique vulnerabilities of kids in the digital space. For example, some states now require businesses to implement heightened safeguards such as stricter age verification protocols, limitations on data collection for minors, and enhanced parental consent mechanisms. So these laws often impose specific obligations on businesses operating websites, apps, or online services likely to be accessed by children. And they are not as straightforward as they may seem, and they introduce some unique compliance challenges. For example, with age verification, businesses often face a dilemma: collect more data to confirm a user's age or potentially create new privacy risks by non-compliance. Additionally, varying requirements from state to state may lead to inconsistent standards, forcing states to adapt their practices based on each jurisdiction.
Okay, and so that's what we're seeing at the state level. Mohammed, can you continue? What are we seeing at the federal level? What initiatives are going on?
Yeah, so there's currently two major legislative initiatives floating around at the federal level. We have COPPA 2.0 and the Kids Online Safety Act, or COSA. So these are kind of shaping the national conversation around children privacy laws. So COPPA 2.0 proposes a significant expansion of what we saw in the original COPPA, and it would include children from ages 13 to 16, similar to what we're seeing across the country, where these state laws are expanding the age gap to which they apply. And they also require explicit consent and prohibit targeted advertising to both children and teens. So COPPA 2.0 would also introduce an eraser button, which allows parents and minors to delete personal information from online platforms. COSA would go even further by introducing a duty of care for online platforms. And this duty of care would require the platforms to activate the most protective settings for children by default, and also provide mechanisms for parents and teachers to report harmful behavior. While these provisions sound straightforward, they place burden on these platforms to comply and also anticipate and mitigate the risks. And we haven't seen that before. There's also an interplay. If both of these laws get passed, how does a business comply with both COPPA 2.0 and COSA, while also the existing and proposed state laws?
Okay. And so I know we only have a couple minutes left, but we can't not end without talking what's going on at the federal level. I mean, we have all these crazy state laws going into effect, and for years we've been saying the federal government's going to step in and help us out. And so I'm going to turn it over to Abba first to talk about what we're seeing happening at the FTC, since they've been the primary regulatory body handling privacy laws in the U.S. So Abba, if you wouldn't mind talking about it.
So the FTC has been on it, and they've been ramping up enforcement recently as well. And they really rely on Section 5 of the FTC Act regarding unfair and deceptive acts or practices. So even they've been really, one of the key things that they look at is sensitive data triggers. So the moment a business talks about sensitive data and sensitive data they might be collecting or using, that's a high level of privacy and obligations, and it's a flag for the FTC. And so recently, even there was a case with a business that was selling software, antivirus software, and in their advertisements, they were saying that they were not collecting consumers' information, they weren't tracking the consumer. But guess what? They were. And it was all sensitive data as well, such as like location information. So the FTC went at settled with them just this year, and I believe they were fined $16.5 million. Now, with respect to that case, we were talking about deception. The latest trend right now is the use of unfair practices, which they weren't really using in the past. But in a recent complaint that was filed, I believe last year, against Brady Analytics, they mentioned that the practice of the organization resulted in unfair sale of sensitive data, unfair collection and use of consumer location data without consent, and unfair sale of sensitive inference derived from consumers' location. What's interesting is that they really didn't really set out and define the correlation between the actions right off the bat and what is considered unfair. They just simply stated, and regurgitated what is considered unfair under the law, which includes likelihood of substantial injury to the consumer, that the consumer themselves cannot reasonably avoid the harm, and that the harm outweighs the benefit. And so with respects to this case, and if you have time, you may want to read it. The complaint was against, the action was against Gravy Analytics. And Gravy Analytics was collecting location information and associating it with identifiable information to the consumer and selling it without any type of consent. The last thing I'll touch upon briefly is dark patterns. Now, dark patterns are design tactics the websites may use design practices to manipulate the consumer into going for signing up for online subscriptions. And what the FTC is looking for when they look at websites is like the security of the key information, tricking users into making payments or sharing data, and creating complex processes for cancellation. They recently filed a suit last year with Amazon, which I believe is going to start in June of this year, that Amazon's interface and design unintentionally led users to sign up for subscription, and their cancellation process is very complex. And then this year, they went after Adobe for Adobe's annual paid monthly subscription plan. So Adobe's website, again, wasn't clear, and consumers were signing up for this annual paid monthly plan unknowingly. And in order to cancel it, there was a huge burden to actually find out where you can cancel it. And then the actual fee for cancellation was hidden under the fine print. So we'll see how that case comes next year as well.
I wanted to thank everybody for attending today's webinar on privacy, cybersecurity, and AI practice. This is our complete practice group. I know only a few of us talked today, but this is our complete group. We have a vast array of privacy professionals, including technical professionals that can help you not only with pen testing and collecting data, but we can help go through and explaining these laws. So with that, I would like to thank everybody for attending today.